You propose a rule, you've got notice and comment, then you issue the final rule, it gets entered into the Federal Register, blah, 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 blah. And generally speaking, you're going to get me all on board for the federal government letting rules die, proposed rules die, because
Yeah, it
what?
usually doesn't go in our favor.
No.
We are the Armed Attorneys. Today we're talking about kind of a unique situation. What if you're out camping deep in the woods, you're in a tent, you defend yourself, but turns out you were carrying unlawfully. Now, welcome to the crazy world of the Army Corps of Engineer land, and that's what we're going to be talking about. Some regulations, some cases, and maybe there's a fix in here, and we need your help with it. But before we begin, show your support for the Second Amendment by hitting that like button. And this question, I don't know what's going on. Maybe it's summertime, people are out traveling, camping, things like that, but folks wanting to carry, obviously, want to defend themselves. Army Corps of Engineer land, record skit.
Yeah. So I think it is because it's summertime.
Yeah.
That's the deal, because it's lovely. You want to go travel. And there are Army Corps of Engineer lands everywhere.
Yeah, throw that. We have a map. I mean, I don't know how well y'all will be able to see this, but there's literally project sites everywhere.
Everywhere. So we have United States code on this, right? So you'd think that it would be clear.
Yeah,
You'd
and
think.
yes, and this isn't 18 USC 930. I think that's our prohibition on federal facilities. So we're not talking about
No,
federal facility carry. We're just talking about
it's just
land.
different.
This is land. I mean, these are campgrounds, these are lakes, these are
Yeah.
rivers. This is all kinds of places where people want to go hang out. And we have this general prohibition in the Code of Federal Regulation, and it's pretty short, so I think we should just cover it.
Sure. Yeah, so it's in the Code of Federal Regulations. Like Richard said, it's Title 36, 327.13, explosive firearms, other weapons and fireworks. We've got the possession of loaded firearms, ammunition, loaded projectile firing devices, bows and arrows, crossbows, or other weapons is prohibited unless in the possession of federal, state, local law enforcement officer, being used for hunting or fishing, being used at authorized shooting ranges, or you've got written permission from the district commander. You can be fined up to $5,000, in prison for 6 months, or both for this violation. So, I mean, rather than just like what we do with national parks, which is we defer
Yeah.
we defer to the state law and we say, don't go in the places, don't go in the improvements. Those are federal facilities, but the lands are okay if it's okay in the state that you're in. You have to get a permission slip.
Yeah, and so, most of us are not going to fall into these categories. Maybe some hunters do, maybe some shooting ranges located on these properties. But, what we saw during the first Trump administration was, hey, guess what? They told these district commanders, hey, folks ask to carry on these locations, you should grant permission. Give them permission. They sent out these kind of 3-page long letters with the don't commit any crimes, you got to be in lawful possession, all these other things. And
Which is great, but don't tell me I need permission.
right. Well, I mean, it's already super burdensome. I mean,
Yeah.
a lot of times people don't know where these project sites are until they are there.
Right, you cross over an Army Corps of Engineer land and you don't know, or you know as you're like, oh,
Yeah.
I see the sign,
Right.
So, I don't know. It's
Yeah,
not
but
good.
so that's kind of the regulation that's in the background. We have this general prohibition, very limited exceptions, kind of unreasonable, and maybe there's a solution to all of this. But we had an interesting case. This is out of the state of Ohio. If you all want to check it out, it's Morris v. U.S. Army Corps of Engineers. This is 900 Federal Supplement Second, 1082. Now this is out of Idaho, 2014, and this
I was gonna say we're in the third sup now, aren't we?
we're in the fourth sub.
We're in the fourth sup.
Yeah, things are
Ooh.
litigating at a breakneck speed.
Time flies when you're having federal court litigation. All right,
Yeah,
go on.
but this court, and this is a pre New York State Rifle and Pistol Association v. Bruin standard. The court chose to apply strict scrutiny to that regulation Emily gave us. And they found, hey, guess what? This thing is an undue burden on the Second Amendment. It's violating these folks' constitutional rights. And specifically, what they were asking for is, hey, I want an injunction so that I can keep a firearm inside of my tent when I go and camp. Hey, this is like my house. I want to be
Yeah,
able to protect myself, going back to kind of that
sure enough.
hypothetical we started with. And the court issued an injunction, dismissed the Army Corps of Engineers, saying, hey, we want you to dismiss this thing. But that's not really the end of the story.
No, and what's interesting is that they applied strict scrutiny, which is great
Yeah,
for 2014.
for 2014, that's great.
But were this to be litigated today, it would be even better hypothetically,
Yeah.
because strict scrutiny, great, less good than the Bruin standard. So, all right, here we go. Should we read this?
Yes, please.
Okay, so strict scrutiny applied in determining whether regulations of the United States Army Corps of Engineers, generally banning possession of firearms and ammunition on property administered by the Corps, violated the Second Amendment to extent that ban would extend to possession of firearms and ammunition in a tent for self-defense purposes. Woo!
Yeah.
Although tents were often temporary structures, a tent provided privacy and security akin to a house, such that precluding firearms in a tent for self-defense posed a substantial burden on a core Second Amendment right. Again, that's strict scrutiny analysis, which is, I mean, was at the time we were like, yeah, that's what you got to do, even though some courts didn't want to do it. But I mean, under Bruin, this would fall apart even faster and easier.
Yeah,
So,
it would just be outright, hey, this is unconstitutional, not just talking about tents here, but the right to keep and bear generally carrying on these lands. So, but we have to see. So that case was started in 2014. It was being litigated up into the point of 2018, and this eventually got appealed up to the Ninth Circuit Court of Appeals. Now, interesting kind of procedural maneuver here. The parties agreed to voluntarily dismiss this case, dismiss the appeal, with the understanding that the Army Corps of Engineers was going to change their policy in their enforcement of this general prohibition on, hey, you can't carry on Army Corps of Engineer land. And the court gives us kind of a sad order and opinion here. Do you want to read that one?
yeah, I'll read this one too. Counsel explained the Corps was considering whether to revise their firearm policy. Defense counsel agreed to provide notice to opposing counsel in the court when the Corps made its decision. When that decision is made, there may be a need for further action in this case, but until that time, the case will languish without any activity, possibly for a lengthy period. To ensure the court's docket only contains cases actively being litigated, the court will administratively terminate this case without prejudice to the rights of any party and reopen the case for any reason.
When a court says
Okay.
the case is going to languish, that's not good.
No, because their definition of languish is different than yours and mine.
Right. We've seen what they think of a speedy trial.
Right, exactly. So, but yeah, I mean, like, and then now it's like, okay, well, we're still waiting.
Yes.
We're still waiting.
Well, and this is during Trump term 1, right? So this is when the Army Corps is deciding to make some changes. And we had, right as Trump was heading out the door, this is in April 30th of 2020, we had a, hey, guess what? Proposed rule change to this Code of Federal Regulations section, the one that Emily covered earlier, that would have revised this policy to make it very similar to what we have with national parks. Hey, if you can lawfully possess and carry the firearm under state law, you're going to be okay, outside of buildings and facilities. And so that made a lot of sense, but it kind of died on the vine. And we'll throw that rule up here just so that folks can see that, but it didn't go anywhere.
Right, because remember, we have the Administrative Procedures Act, which I generally love, but, you propose a rule, you've got notice and comment, then you issue the final rule, it gets entered into the Federal Register, blah, 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 blah. And generally speaking, you're going to get me all on board for the federal government letting rules die, proposed rules die, because
yeah, it usually doesn't go in our favor.
No, more regulations are never a good thing. But this is different because it wasn't more regulation, it was subbing out a better regulation for a bad regulation. And it died. And so that is a little bit disheartening because this is the way absent waiting on the Corps of Engineers to just sua sponte change its policy, which I guess is good, but then if they can just change their policy, they'll do it again under a anti-gun administration, and then we're back where we started. We sort of need this CFR portion to change.
Yeah, so and just so you have it, it's COE 2018-0008, if you wanted to go check out that rule. Now, all right, guess I'm going to surprise everyone here, so hold on to your socks. But when Biden assumed the office of the presidency, they didn't seem to care about gun rights as much.
What?
So, I mean, that's why that rule didn't go anywhere. And, this whole, hey, district commanders give everybody permission, kind of saw that go away too. And so I think this is a fantastic opportunity for everybody watching this to maybe we can get this thing fixed.
I think we can get this thing fixed. Call to action.
Yeah. So this is one of those things where, hey, you need to reach out to your representative, your federal representative, your House member, your senator. The hard work's already done. We already have this rule. It's pretty easy to throw a rule up, let it sit for the required time period, let everybody talk what they're going to say, and then let the rule pass and change and go into effect. This one would be an easy win.
Yeah, let's move.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, question and comment for us below. Until next time, we're the Arms Attorneys.